The MEPs opposed the planned release of data transfers to Great Britain. The problem is the mass surveillance there. The European Parliament called on the EU Commission on Friday in a resolution passed with a narrow majority to revise its plan, according to which companies and authorities would initially be allowed to transfer personal data from the EU to the UK for 4 years. UK practices in mass surveillance and data sharing based on international agreements would need to be clarified before a potential release, they say. 344 MEPs voted for the resolution, 311 were against, 28 abstained. The representatives of the people openly go on a confrontational course to the Commission. They underline that the national data protection authorities of the member states should, if necessary, suspend the transfer of personal data to the UK if arbitrary access to information about EU citizens is possible there. MEPs also point out that no spy agreements between EU countries and the UK could help solve the problems. These are agreements to prohibit the spying of data on citizens and companies of the parties involved. In this country, CDU politicians, the Christian Democrats in particular, presented a no-spy agreement with the USA as tangible before the federal election in 2013 at the height of the NSA scandal after the Snowden revelations. It quickly became apparent, however, that the US government did not want to oblige its security authorities to comply with local law with its comparatively strict data protection regulations. The EU Parliament now states that the basic British data protection framework is similar to that of the EU. However, it considers the implementation of the requirements to be inadequate. In particular, the rules in the UK included exceptions in the areas of national security and immigration, which now also apply to EU citizens living or planning to settle on the island. Current British legislation also allows large amounts of data to be accessed, including those of innocent people, and to be retained. The European Court of Justice, the ECJ, has repeatedly stated that such arbitrary measures are not compatible with the General Data Protection Regulation, the GDPR. MEPs also stressed that UK metadata provisions do not reflect the sensitive nature of such information and are therefore misleading. However, they also acknowledged that UK lawmakers have now given citizens better legal remedies against surveillance and have improved control over data interception for national security reasons through reporting requirements. The civil rights organization Privacy International was able to achieve in long-term legal proceedings that the Secret Service, the GCHQ, is no longer allowed to hack smartphones, computers, and entire networks abroad on the basis of general court orders using state Trojans, or Trojans in English. According to the resolution, an agreement between Great Britain and the USA ensures that information about EU citizens can ultimately be passed on to authorities on the other side of the Atlantic. This contradicts the ECJ rulings against the Privacy Shield and the previous Safe Harbor Agreement, according to which US laws allow mass surveillance by security agencies such as the NSA or the FBI. The data protection standard there therefore does not correspond to that in the EU. The MEPs therefore urged the Commission and the UK authorities to look into all of these issues. They insist that the adequacy decision envisaged by the EU executive should not be made until then. The objections of the European Data Protection Board, the EDPB, would have to be taken into account. Justice Commissioner Didier Reynders had emphasized before the vote that the current legal situation in Great Britain is very similar to that in the EU. Future deviations are possible, however, which is why the adequacy decision should initially be limited to 4 years. The final decision by the Brussels government institution is expected in the coming months. But if they decide to do that, I am quite sure that this will end up in the ECJ. And I'm sorry to say that I predict that the ECJ will overrule that if they do that. And if you want to stay informed, please subscribe to my channel. I'll see you in my next video. Auf Wiedersehen.